Joining me today for a conversation on fair use in the educational setting is National Music Council Chair Charlie Sanders. Charlie is a former copyright fellow at NYU School of Law, an adjunct professor at NYU, and counsel to many music creative organizations, including the Songwriters Guild of America. Charlie, thank you for joining us today.
James, my pleasure. Good to be here.
All right, let's dive into this. Where are we with copyright? How did we get here?
Well, really brief historical background is that at about the time of the French Revolution and the American Revolution that preceded it, there was the awakening that we wanted a robust marketplace of ideas in a democracy. And the two elements that we identified as being very important in establishing that are the free speech principles that we all know, and the protection and encouragement of professional creators and others to be able to earn a living from their writings and creations.
And this is why it's in Article 1 of the U.S. Constitution.
Yeah, that's correct. You know, most people think that fair use and copyright are in conflict with one another. They're really not. James Madison, who wrote the First Amendment originally and certainly developed those free speech principles into doctrine, also was a principal in writing the U.S. Copyright Act.
Right.
And there was a recognition that there would be times when there needed to be exceptions to copyright protection for the greater good of society. But those exceptions are pretty narrow, and the courts have developed this doctrine as really a safety valve, calling it the fair use, the unlicensed use of a copyrighted work for a particular purpose that serves society's needs more than the protection in that particular narrow instance of the creator's rights to remuneration, payment, royalties, whatever you want to call it.
Now there's 4 factors to fair use that exist.
Yeah, in 1976, after more than 100 years of judges individually applying whatever doctrine they thought they needed for fair use.
Right. Well, because everything is individual case load when it comes to fair use, right? There's no blanket.
The thing about fair use is precedent is very nice, but every single case comes down to the individual facts of that individual instance, and it can turn on what most people would consider very minor differences in facts from past cases. Plus, it's being applied by judges all around the country,
right,
who don't necessarily follow one another exactly, unless the Supreme Court rules, and it rarely does in fair use cases.
So let's go back to those 4 factors.
Well, Congress decided to enumerate 4 factors that it wants judges to consider. Not in the order, but in the easiest way to think of it. The first is, what is the nature of the copyrighted work that was taken? Yeah. Is it a creative work of fiction that somebody sat down and thought up? Or is it Zapruder standing on the pergola in Dealey Plaza shooting film of what turns out to be the assassination of a president? Those are 2 very different things that lend themselves to fair use in very different ways. The second element is, what is the nature of the use? And the word transformative is often used in that instance. Is the use something that serves the greater good of society, important, political, or is it commentary? Is it criticism? Something that would make the ordinary layperson say, well, that really ought to be a fair use. It's not sharing files of entire musical compositions on the internet. The third factor, of course, is the amount taken. Yeah. Did you take the whole thing, or did you take only what was necessary to make the point that you were making in your criticism and commentary? And the fourth, and what's often considered, or at one time was considered the most important, is the economic harm that's likely to have been caused. Right. Is the person using the copyrighted work without permission usurping the market for the original? And is that one of the principal intents? Even if they're not using it for profit, is it depriving the copyright creator and owner of their profit by usurping the sale.
Because at the end of the day, right, the composition that could be being used is the intellectual property of the person who did the composition.
Absolutely.
Yeah.
And you don't have to register a copyright to own the copyright.
Right.
This is something that most people don't understand, but when they talk about, when we say in conversation, did you copyright that? That means did you register that?
Mm-hmm.
Because the second your idea becomes an expression in any form, on film, writing it down, on digital means of creating music, it is protected by copyright. And that is the universal standard.
So how do we get to where we're at now? I know AI is becoming a big thing, so we need to start looking at what do we do with creators because of how, we talked earlier about how they ingest the material. So where does that go and what does that mean when it comes to fair use and how are we supposed to navigate that?
It's not going to be easy. Clearly, nobody wants to stop the march of technology,
Right.
and you couldn't if you wanted to.
Right. It's like putting toothpaste back in the toothpaste bottle.
But on the other hand, we need to decide as policy on a global basis, really, how much do we want to protect human creativity over machine-driven creativity? Mm-hmm. And right now, when it comes to AI, we talk about, the technology folks want to talk about training
Right.
the AI system. Now, if you look it up in the dictionary, training is something that you do to people and higher animals.
Right.
It's not something you do to a machine. What they're doing is ingesting already created works and using an algorithm to use those works to create derivatives.
Right.
So the question is, how are we going to develop a system that compensates the creators whose works are being loaded, while still allowing the technology to do what it does, putting aside the issue of job displacement,
Right.
which may end up being the most important factor of all in how this plays out.
Mm-hmm.
But it's going to be a very difficult intellectual exercise in a practical economic world as to how we're going to apply this. Now, in the educational field, it's even more complicated.
Right.
In terms of plagiarism and issues of generative AI and how that's going to be controlled in educational settings. But, we're going to have to work it out because the technology is not going away.
Right. I mean, you bring up the education stuff with the plagiarism, right? So like in my day job, right, I oversee high school performing arts, and one of the things we do is limited prep events for things. And so how does that generative AI now become used within that competition setting and in the educational setting? So whether we're writing papers or getting a speech ready or anything like that, how do we track what happens there? Most schools are now going over to plagiarism because they're using words that aren't their own, but eventually that's going to be very difficult to find.
Yeah, I think that we're truly going to have to put our heads together to figure out the relative importance of originality and how much we prize that of human creation as opposed to building what's already been,
Right.
even if it's paid for. Is the end product still going to add to culture in a way that is human expression and instructive, as to how to live a better life or a richer life in terms of enjoyment of art.
Right.
So,
I mean, the good thing is I don't think anyone's going to go to a concert and watch a computer screen do the music. So at least we're okay for now. But
that is true, but they might go to a concert to see a band play a song that was written through AI.
Yeah.
So,
does that make all live bands cover bands then? Is that
it it might.
It could. Yeah.
Absolutely.
All right. So let's go back to schools and fair use. We mentioned that just a little bit. But let's go back to what schools are in fair use. So the famous case, at least recently, is the Burbank High School case, dealing with a show choir that used bits of material, and then we had another group that's like, nope, wait, that's not how this is going to work. So everyone went to trial. Usually education cases don't go that far in trial, but this one did. So can you walk us through a little bit of this one?
Sure. The Copyright Act has an exemption for performance in face-to-face student settings. So there's no performance right. But frequently, schools have musical performances in which they play off sheet music.
So we're talking like show choir, marching bands, those kind of things.
Right.
Yeah.
Now, it may not be physical sheet music anymore. It may even be on a tablet, but
Right.
it's still in written form.
Yep. The intellectual property is still intact.
Now, if we go back in history, traditionally, there were song pluggers who worked for music publishers and songwriters and composers who attempted to get songs played because they wanted them performed. And the notion that you could arrange a song for yourself or a composition for yourself and then play it was never really a question of law. It was a question of economics. People were happy to get a cover, were happy to get a recording, etc. The Copyright Act provides that you can arrange a work the way you want it if you're making a recording of it.
Right.
But there is no right presently in the Copyright Act that would allow, if you have a performing right and a sheet music right, to make a new arrangement. So music publishers, again, as representatives of songwriters in many cases, felt that the streams of income that they were used to were drying up in the digital age for any number of reasons that we can discuss later and in future discussions. And they decided that they wanted to be paid for arrangements of works that are being done by schools. And one of those schools was Burbank High,
Burbank
High School. And the suit was brought in California and went up to the Ninth Circuit Court of Appeals. It's a federal case. All copyright cases are brought in federal court. And the judge was rather upset with the fact that the plaintiffs in that case, acting on behalf of the music publishers and songwriters, did not have exclusive rights. And on that issue alone, they denied the copyright infringement. And
because they were portraying them, correct me if I'm wrong, the plaintiffs were portraying themselves as having those exclusive rights.
Correct.
But in reality, there's multiple different pathways that school could have achieved those rights.
So the question becomes, did that settle anything? It might have, but rather than continuing to litigate that issue, there are other avenues available in terms of asking Congress to step in potentially. The tradition always was to move away from compulsory licenses, to force the licensing of something at a government set rate. But more and more we're seeing that, especially in the United States, become the antidote for, in the digital age, for getting people paid, although not in the amounts that we in the copyright and entertainment area would like. But that's a matter of setting rates, not setting rights.
Right.
So it's possible that we'll see a legislative approach to resolving that issue. I think that would certainly be far better than having litigations all over the country constantly, and bringing pressure to bear on schools to pay money maybe that they don't have. I mean, we're always seeing budgets slashed.
Right.
So, there are good points on both sides. As a copyright advocate, I'm not going to say that, we should do away with the right.
Right.
But
it should be easy, right?
But it's a difficult situation.
Because I know I deal with schools all the time, right? And so like trying to help them navigate how to get the proper permissions and the right rights. It's a horrible phrase, but the right rights. It can be a challenge and it can be expensive. So I think the idea of just having some sort of a pathway, because I don't know of any music director out there that's like, I don't want to pay the right thing. I just want it to be easy and accessible.
Yeah, I think that's true.
Yeah.
And streamlining is not something that the music industry has been very good at.
Yeah.
The licensing system is arcane and complicated, and there's been a movement lately, again, towards compulsory licensing and collective licensing, blanket licensing of an entire, universe of works at the same time. Maybe in the long run that is going to have the effect of resolving these issues and getting everybody paid and making users happier, that they do not have to jump through a series of hoops that take a lot of time and effort.
there's still a lot of work to do. So,
No question.
but we know for sure that the Burbank case didn't really change the trajectory all that much.
Well, it changed it in a sense that it put an exclamation point on the fact that if you're going to bring such a lawsuit, especially against a school, that you must have exclusive rights as a
Gotcha.
third party.
Yeah.
So having a collective agency assign those rights to do that has to be done in the right way.
Gotcha.
It's a formalistic standard, but one clearly that the Ninth Circuit felt was important enough to throw the case out on.
Yeah. And we should say that if this case would have been tried in a different circuit, the outcome could have been different.
It is possible.
Yeah. We hope it wasn't, but it could have been.
In copyright cases, anything is possible in any jurisdiction in the country.
Fair enough. Fair enough. All right. So why are we seeing so many more copyright infringement lawsuits now over the last 10 years than we had previously?
Yeah, it's in the news a lot.
Yeah.
I mean, as we're sitting here, the Ed Sheeran case is proceeding in Manhattan. I think that I think it's Manhattan. I think that it's a realistic response to the fact that in the digital age, and we went through the entire period of what was called piracy, of file sharing.
Let's go back to Napster.
I mean, you saw an industry downsized by about 60 to 70%.
Yeah.
And the search for new streams of income eventually included litigation as an income stream to produce or reduce losses that were accruing because music is distributed and enjoyed in a different way.
Yeah. Well, because let's be real, right? Like if creators don't get paid for the work they're doing, they're going to stop creating.
Yeah, I mean, I think that if you look at the songwriter community as an example, it is very difficult to earn a living as a composer or a songwriter now. Whereas, there were thousands of professional songwriters in the 1990s.
Sure, yeah.
The migration over to a singles market, putting aside piracy or looting or whatever you want to call it, we changed the way music is sold and distributed, and it cut down on the number of compositions that actually get used and make money.
Right.
So we have a situation where you have huge numbers of compositions being created and a much more democratic way of distributing music without a gatekeeper, but far fewer songs earning enough money to support the creators.
Yeah, there's what, billions of songs on like Spotify and other streaming services, but how many of those really get the lion's shares of the dollars coming in from those streaming?
Very few.
Right.
This takes us back a little, and again, all of these issues run together.
Right.
But AI creations being used and mixed in on playlists, for example. So you take 3 real songs that are hits and put 35 AI created works that are owned by the person or company distributing the playlist. You can manipulate the system as far as who's getting paid the royalties that are due. So it's a very complex situation, and everybody in the industry is aware of it, but not really sure how to resolve it yet.
Right. Well, going back to that idea, you have the AI creating it, but do the AI compositions, are they actually owned by someone? Or are those technically considered public domain?
Well, so far, the U.S. Copyright Office, as well as several of the European copyright societies and registration arms of the government, have refused to register pure AI-generated works and insist that there be a minimum level of human interaction is the wrong word, human participation in the creative process and human contribution to what the final copyrighted work looks like.
I know some of these questions aren't easy to answer. We got through them all and it was good. Please do join us for our next discussion on fair use as it pertains to creating derivative works. For the National Music Council, I am James Weaver.
In the interest of keeping the NMC membership up to date on the important issue of fair use in the United States, we're providing this additional update to the previous presentation to alert you about an important case recently decided by the U.S. Supreme Court. In the case of Andy Warhol Foundation for the Visual Arts versus Goldsmith, the issue of transformation as it applies to the fair use doctrine was significantly narrowed by the court in late 2023. Let me briefly explain that development. 30 years ago, the Supreme Court ruled in the case Campbell versus Acuff Rose Music, Inc., better known as the Two Live Crew Oh Pretty Woman case, on the issue of what types of uses most lend themselves to protection under the fair use defense as an exception to copyright infringement. The court stated in 1994 that if the use of a prior work was transformative in any significant way, that factor weighed in favor of a fair use finding. For instance, since Two Live Crew's use of the song Oh Pretty Woman in a new work could be considered by some to be a parody rather than a mere lyric substitution, that was transformative enough to favor a finding of fair use. In the more recent Warhol case, however, the court has substantially changed course. Justice Sonia Sotomayor, writing for the majority, first explained that all creators of copyrighted works are granted by the U.S. Copyright Act the exclusive right to create derivative works from their original work. That 2023 opinion went on to conclude that, quote, an overbroad concept of transformative use, one that includes any further purpose or any different character, would narrow the copyright owner's exclusive right to create derivative works. To preserve that right, the degree of transformation required to make transformative use of an original must go beyond that required to qualify as a derivative. An independent justification like this is particularly relevant to assessing fair use where an original work and the copying use share the same or highly similar purposes, or where wide dissemination of a secondary work would otherwise run the risk of substitution for the original or licensed derivatives of it. Once again, the question of justification is one of degree. Thus, it is not sufficient simply to conclude whether or not justification exists. The question remains how powerful or persuasive is the justification, because the court must weigh the strength of the secondary user's justification against the factors favoring the copyright owner. In sum, the first fair use factor used in deciding fair use cases under the Copyright Act considers whether the use of a copyrighted work has a further purpose or different character, which is a matter of degree, and the degree of difference must be balanced against the commercial nature of the use. If an original work and a secondary use share the same or highly similar purposes, and the secondary use is of a commercial nature, the first factor is likely to weigh against fair use, absent some other justification for copying. As you can see from this opinion, a defendant merely stating that a new use is transformative and therefore likely to be a fair use is no longer a persuasive argument. NMC members are therefore urged to consider the ruling in the Warhol case and any subsequent decisions and changes in law and interpretation when evaluating the strength of fair use claims. The safest course is always consultation with a copyright attorney fully versed in the application of the fair use doctrine. Whenever possible, NMC will provide updates on these and other issues. Thanks for listening, and as always, thank you for your support.